Welcome to Chapter 5, Constitutional Law. The United States Constitution, the greatest legal document ever written, is a series of compromises about the power of government. The compromises affect every citizen and company in the nation, every day. John Milton once said, "Give me the liberty to know, to utter, and to argue freely according to conscience, above all liberties." Before the Revolutionary War, states wanted a confederation with weak national government and very limited powers. After the war, in 1787, the states voted to amend Articles of Confederation and create a new federal government that shared power with the states. The U.S. Constitution is an amazing document in many ways. It was drafted in 1787, but it's relevant today. It's short and easy to read. It's flexible enough to deal with issues of a changing world. It's versatile enough to resolve a wide variety of conflicts, and it leaves room for interpretation. When America gained its freedom from England in 1783, the states governed themselves under the Articles of Confederation. This gave the federal government no power to raise money or regulate commerce. Taxation policies were inconsistent and caused dissent among states. The Articles of Confederation simply were not working. The states sent 55 delegates to meet and amend the Articles of Confederation. Instead, these men became the framers of the Constitution when they decided that an entirely new document was needed. They debated over how much power to give the federal government, the states, and the people. The result was a series of compromises about power. The Constitution established a federal form of government with checks and balances among three branches: executive, legislative, and judicial. National government has limited powers delegated from the states. The federal government is divided into three branches to help ensure a balance of power. Each branch is independent and equal. While the original Constitution did not mention the rights of citizens, this was added later in the first 10 amendments, or the Bill of Rights. Article 1 established Congress with 2 houses. Each state has 2 senators, while the number of representatives is relative to the state's population. Article 1 gives Congress certain powers. Congress can create and enact legislation, impose taxes, spend money, create copyrights, and support the military and declare war. Congress also regulates commerce with other nations and between different states. Substantial effect rule states that Congress may regulate any activity which has a substantial economic effect on interstate commerce. Every state has a great deal of power. For example, they can regulate commerce within their own borders, so long as they don't discriminate against interstate commerce, because this is unconstitutional. But with as much power as every state has, there is the Supremacy Clause. This states that the Constitution, federal statutes, and federal treaties are the supreme law of the land. If there's a conflict between statutes, the federal controls the issue and the state statute is void. Even with no direct conflict, federal law will prevail if the issue is one that Congress controls exclusively. So, state law prevails only when there's no opposing federal law and no exclusive federal control. States have clashed with the Supreme Court on many issues. One such case was Barnes v. Glenn Theater. Indiana's public indecency statute prohibits any person from appearing nude in a public area. A nightclub called the Kitty Cat Lounge and several dancers who wished to perform nude filed suit seeking an order that the statute was unconstitutional. The U.S. District Court ruled that the dancing was not expressive conduct. The Court of Appeals reversed, declaring that it was non-obscene expressive conduct and thus protected by the First Amendment. Indiana did not argue that the dancing was obscene. If that were the issue, the Miller test would have determined the outcome. Instead, Indiana claimed that its general police powers, including the power to protect social order, allowed it to enforce such a statute. Does Indiana's public indecency statute violate the First Amendment? The holding was that although the court was sharply divided, it upheld the statute. The court, per Chief Justice Rehnquist, held that this dance is expressive conduct but only within the outer perimeters of First Amendment protection. The state has a substantial interest in protecting societal order and morality, and as the statute only incidentally limits some expressive activity, it does not violate the First Amendment. What are a state's police powers? The police powers are the inherent rights of states to enact laws to promote the general health, safety, and welfare of their citizens. Do you think it's important that Indiana did not argue that the dancing was obscene? Possibly. Had the court applied the Miller test to determine obscenity, the result may have been different because the Miller test requires a number of subjective determinations. What specific purpose did the Indiana statute serve? Indiana defended the statute on very general grounds, that it served public health, safety, and morals. It did not specify the particular ills it addressed. Do you think a state law that interferes with expression requires strict scrutiny? Usually. The court's response to this case was fractured, with Chief Justice Rehnquist and Justices O'Connor and Kennedy agreeing that the statute did not violate the First Amendment, and Justices Scalia and Souter concurring in the result, but not the reasoning. Justices White, Marshall, Blackmun, and Stevens dissented. In other words, the only reasoning that commanded more than 3 votes was the dissent. Article 2 defines the powers and responsibilities of the President. In general, he or she is to enforce the nation's laws. The President nominates federal judges and the heads of most administrative agencies. The President and his or her advisors can propose bills to Congress, and then the President can veto bills from Congress. The President coordinates international efforts, negotiates treaties, and is the commander-in-chief of the military, but may not declare war.